Hi everyone, Derek Johnson with Tatango.com here. Today we're going to be reviewing and better understanding the TCPA requirements for text message marketing. TCPA is short for the Telephone Consumer Protection Act. So who am I? Again, my name is Derek Johnson. I'm the founder and CEO of Tatango. It's been 7 years we've been in business, and all those 7 years we've been helping businesses from small to large understand text message marketing, launch text messaging campaigns, and importantly, be in TCPA compliance. So this webinar is going to cover a bunch of different topics. We're going to cover all the different groups and organizations that are involved in regulations and guidelines, such as the CTIA, the FCC, and the MMA. We're going to talk about the history of the TCPA. We're going to talk about advertising requirements for compliance in the TCPA, exceptions to the TCPA requirements, messaging requirements in the TCPA, enforcement of the TCPA, record keeping and disputes in regards to TCPA compliance, and notable TCPA lawsuits. So this is going to be a rather long webinar, but we're going to cover a lot of stuff, all relating to TCPA, and very important for any SMS marketer that is either running an SMS campaign, thinking about running an SMS campaign, or just doing research on SMS marketing. So let's start off talking about the different organizations that are involved in the laws, the regulations, the guidelines regarding SMS marketing. So first is the CTIA. They're created by the wireless carriers. They're in charge of enforcing SMS marketing practices. So they have a thing called the Mobile Commerce Compliance Handbook. This is pretty much like the Bible for short code marketing. It says what you can do, what you can't do, and it's very specific. So you're going to see things like put message and data rates in. Here's what has to happen when people reply stop and help, and this is what has to be included in your terms and conditions and your privacy policy. They are very specific because the CTIA does audits on SMS campaigns. They'll go out and search for SMS campaigns and make sure you're following the rules in the Mobile Commerce Compliance Handbook. The CTIA guidelines aren't law, though. You can't be sued based on violating CTIA rules. What can happen, though, is if you receive an audit and you don't respond to the audit, you don't fix the issue, the carriers can either terminate your shortcode or shut down your SMS campaign, which is never a good thing. So you definitely want to follow CTIA guidelines. FCC. This is the Federal Communications Commission. This is the one that organizes and enforces the TCPA, which is the Telephone Consumer Protection Act, which is what this entire webinar is about. The TCPA is law. It's actually federal law, so it's something you definitely want to follow. The reason being is under the law, you can be sued. Unlike the CTIA, which you cannot be sued under, you can just have your shortcode shut off, your campaign terminated. The TCPA is something that consumers can actually sue your business for not compliant. Okay, so the TCPA is very different than the CTIA in that the TCPA is all about businesses receiving permission from the consumer to text message them, and the specifics around how this permission can be gathered and what is allowed after the permission from the consumer is received. The TCPA has nothing about message and data rates, what happens if you apply help. It's much more broad, and the TCPA does not just talk about text message marketing. It's really any telephone communication, even includes fax machines to consumers from businesses. Then you got this other organization, which is called the MMA, which is the Mobile Marketing Association. They also release a set of documents and their best practices. So similar to Mobile Compliance Handbook, the CTIA has their own handbook, which a lot of the stuff is similar, but it makes it very confusing for brands and for marketers because one thing may be addressed in the CTIA and it'll say take a left-hand turn, and in the MMA compliance handbook, it will say take a right-hand turn for the exact same thing. Well, you have to understand that MMA is just best practices. It's not enforced. If you violate any of the rules in the MMA guidelines, it's not enforced. You can't get your campaign shut down. So what I like to do is I like to focus my efforts on the TCPA and the CTIA. You can definitely read the MMA guidelines, and they're a great organization promoting, mobile marketing. But the guidelines they have, I think, just add industry confusion when we already have enough guidelines. So let's talk about the history of the Telephone Consumer Protection Act. So the Telephone Consumer Protection Act was developed in 1991, and it was a new law that restricts telephone solicitations from businesses to consumers without an established business relationship. This means businesses could just not, call you out of the blue if you've never done business with that business. Now, if you had done business with that business in the past, like you had purchased something or had, talked to them in the past, then, this law would not apply. So in 1991, there was still a lot of telephone spam because think about how many people you do business with, and it's kind of hard to trace back who you do business with and, oh, well, I talked to that person, therefore now I can, call them and telemarket to them. It was very hard to establish really who had an established business relationship with people. So, it helped, but it didn't help enough, in my opinion. In 2007, which is a lot more years later, the Ninth Circuit determined the TCPA, which is a law, applies to unsolicited text message marketing. So in 1991, it was really about like fax machines and phone calls. And they said, because really that's what everybody was doing is phone calls and faxes. 2007, a court case was brought up and it said, hey, look, we're suing based on the TCPA, even though the TCPA doesn't say text messaging, it's still a telephone call, that's what they were arguing. And the Ninth Circuit determined that the law, the TCPA, applied to text messages as well as phone calls and faxes and all those other things. So 2007, that's when it got serious for text message marketing because it said, hey, text message marketers, you now have to comply with the TCPA. In February of 2012, the FCC, again, the Federal Communications Commission, they're the ones that organize and enforce the TCPA. They announced changes to the TCPA, which they call amendments, and they said it was going to take effect on October 16, 2013. So the FCC gave a lot of notice, a lot of time, and then October 16th, things changed. And things changed, in my impression, for the better. Because back, here, even in 2007, when they did say, text messaging is now part of the TCPA and applies, still, it only required a business to have an established business relationship. To me personally, that doesn't make any sense. If I go to a business or let's say I just call Domino's and I order pizza from Domino's, that really shouldn't give them the right to send me text messages. But based on 1991, when the law was written, it said, consumers can, a business can not text message, but, phone call a customer as long as they've had established business relationship with them. And then in 2007, they said, that also applies to text messaging. So just because I called Domino's, especially after 2007, I don't believe personally that they should be able to text message me, which is what in October 2013, the TCPA changed their law or amended it to be more appropriate and I think reduce spam and make text message marketing a much more viable and acceptable way to communicate to customers, and a way that the customer and the business both are on the same page, that they're both understanding that the customer's signing up and the business is going to send them text messages, which from my perspective, that's the best kind of marketing when everybody is opting in, the business and the consumer. So let's talk about what changed. So the established business relationship requirement was replaced with a prior written express consent requirement. And I'll go through all these in a little bit. but just kind of know where things are going. Then also, the prior written express consent, which replaced the established business relationship, cannot be a condition of purchase. Again, I'll explain it later. Third thing, both requirements need to be clearly displayed to customers before they opted into a text message marketing campaign. Pretty simple. There's a lot of changes, but these were the main changes that affect text message marketing. So let's go and talk about these. So let's talk about prior written express consent. It's a mouthful, I know. Luckily, though, a lot of the things in here, like written consent, it makes it sound like you have to take out a pen and paper and have to sign something. Well, that'd make it very, very hard for text messaging because people opt in on the web, they opt in through their phone. Luckily, there's a thing called the E-Sign Act, which it said website form submissions or electronic submissions, similar to a text message, will suffice. So yes, it does say written express consent, but because of the E-Sign Act, you can do it digitally. Okay, so there's two requirements to get prior written express consent from your customers for text messaging under the Telephone Consumer Protection Act. First, you have to make sure that the customer knows that prior written express consent applies. They have to consent to receive text messages. Again, back in the day, 1991, it said you just have to have a business relationship with them. Now, you have to disclose to the customer, and this is the disclosure, by participating, you consent to receive text messages sent by an automatic telephone dialing system. So the Telephone Consumer Protection Act is very specific about what kind of messages. Messages from an automatic telephone dialing system. This means if you have your own phone and you text message your friend, that's not an automatic telephone dialing system. An automatic telephone dialing system is where, electronically it is, creating the messages and sending them out automatically, which is what a text message marketing provider like Tatango does for their clients. So if you're using a text message marketing provider, you are using an automated telephone dialing system. So this is what needs to be disclosed to customers, and the disclosure needs to be made clear and conspicuous to customers. This means that you cannot hide it. You cannot have an ad on a billboard and then, in the grass, put, by participating, you consent to receive text messages. It has to be up there and clear and conspicuous. Now, it doesn't need to be as large as the call to action, like text pizza to 33733, but it needs to be on that billboard. Condition of purchase consent. That is the second piece of the amendment that happened to the TCPA. It sounds really weird and kind of confusing, but it's really simple. Customers can't be forced to consent to receive text messages from your business when they make a purchase. Okay, let's break that down. Customers can't be forced to consent to receiving text messages, so they're not forced to receive a text message from your business just because they made a purchase at your business. So if you go up to McDonald's and you order a Big Mac, McDonald's cannot say, well, we have to get your phone number and you have to consent if you're making this purchase. That is exactly what they don't want happening. Again, just like the prior consent, disclosure must be made clear and conspicuous to customers. Consent to these terms is not a condition of purchase. You don't need to consent to receive text messages just to make a purchase. To make it easier, disclosure must be made clear and conspicuous to customers. It's the exact same here. I like combining just both these disclosures into one disclosure and putting them in the same place in the call to action. Okay, so remember we talked about those different bodies. There's the FCC, which controls and enforces the TCPA. Then there's the CTIA. Then there's the MMA. Okay, the CTIA has some requirements. And again, CTIA is the one that it's not only best practices, it's actually enforced. So you want to follow these. They require a few things. Again, you can't be sued under this, but your campaign can be shut down. I'm going through this because when you advertise your campaign, the CTIA requires something and the TCPA requires something. So let's look at both of them and then let's combine them. So the CTIA requires that you have a recurring program description which it makes a little more sense when you put the call to action up there, which I'll show next. But it would say something like, and subscribe to receive recurring, again, that's the first part, recurring program description, recurring SMS offers. That's the program description part. You have to be very specific about what they're opting in for. Number one, that they're going to receive multiple messages from your business. And number two, what kind of messages? SMS offers, SMS weather alerts, SMS promotions. You know, there's a million different things you can put in there. I don't care what they are. You have to disclose it though. Then you have to give stop instructions. Again, this is CTIA requirements, not required by the TCPA. Nowhere in the TCPA does it say anything about any of this stuff, or even this, it doesn't even mention the CTIA. So stop instructions. Because this is in bold, that means it also needs to be in bold in your advertisement. Something along the lines of text stop to opt out, something very simple. You got to give a cost disclosure too. Message and data rates may apply. This simply means that if you pay per text message, you're going to pay per text message when you receive text messages from a business. Then you need a link. Again, this is what is going to be displayed on the billboard or the television or even the radio ad. You'd have to speak this for a radio ad, but you need a link to a website link to the terms and conditions and the privacy policy for the SMS campaign. So something along the lines of TNC/privacy policy, bobsburgers.com/SMS terms. This would be the Bob's Burgers SMS campaign terms. So as you can see on the bottom here, we've written it all out. This is what it would look like. Again, this is the CTIA requirement. So when we combine this with the TCPA requirements, this is what you get. Top part, 20% off your next purchase. Text Bob's to 12345. That's not required by anybody, CTIA or the TCPA. It's just good practice to put how to opt in at the top. Okay, then we go to CTIA. And subscribe to receive recurring SMS offers. This is the recurring SMS program description. Recurring and SMS offers. That's what it is. Okay, then we go to TCPA. By participating, you consent to receive text messages sent by an automatic telephone dialing system. That's the first part. Remember the first part we went through, the consent to receiving text messages. Then the second part of the TCPA compliance is consent to these terms is not a condition of purchase. This means that if you make a purchase, you're not required to consent to receive text messages. You actually have to want to receive text messages, and it has to be separate from the purchase. Now, this doesn't mean if you want to purchase and you want to opt into an SMS campaign, that doesn't mean that is illegal. You can do that. It's just they can't be coupled together. Okay, then we go down one more row. A lot of people think this is like message and data rates is addressed in the Telephone Consumer Protection Act. It is not. This is a CTIA requirement. Message and data rates may apply. Another CTIA requirement is text stop to opt out. Again, that needs to be in bold. Another CTIA requirement is a link to the terms and conditions in the privacy policy, which we have at the bottom here. So this right here is a billboard. This could be on television. This could be on the web. This is a fully compliant Telephone Consumer Protection Act and CTIA advertisement. It isn't that hard, to be honest. Okay, let's talk about exceptions. Most businesses, these exceptions don't apply, but let's just go through them so you're aware of the exceptions. The exceptions to the TCPA, especially the amendment that was done. If it's a purely transactional message, like account alerts, travel updates, shipping notifications, a lot of the rules don't apply. If it's an entity regulated by the Health Insurance Portability and Accountability Act of 1996, a lot of those things don't apply. Again, if you fall within one of these things, go talk to an attorney regarding the TCPA. These are very kind of edge or fringe cases where 99.999% of the businesses we deal with fall under the TCPA and have to comply with the TCPA. If you're a tax-exempt nonprofit organization, there's some different things you don't have to. A lot of the parts of the TCPA don't apply to you. Political organizations, customers, wireless carriers, a lot of the TCPA doesn't apply to them either. Also, debt collectors. I don't know why that's in there, but that's just in the law. That's the way it's written. Okay, so messaging requirements. This is the stuff that is more specific to text message marketing that's in the TCPA. it says that there must be an opt-out mechanism. Okay, so that's all it says, though. There must be an opt-out mechanism. It doesn't really say what that opt-out mechanism must be. It doesn't say, oh, you have to apply stop or, and cancel, unsubscribe. No, it just says there has to be a stop mechanism. Luckily, the CTIA has stepped in and said, well, they're not law. We're going to give you some, options. So the CTIA requires that the opt-out mechanism be a response to a shortcode with the words stop, end, cancel, unsubscribe, or quit. Okay, so that's one piece, the opt-out. The second piece is sending time frame. You cannot send before 8 a.m. in a subscriber's own time zone, and you cannot send after 9 p.m. in a subscriber's own time zone. So, that makes a lot of sense too, because no one wants to get a text message before 8 a.m. and I'm already in bed by 9, so I don't want to receive any text messages either. But again, that's part of the TCPA. Okay, so let's talk about, remember, CTIA, the enforcement is done by the CTIA. They'll pass it off to the carriers if you're in violation and you don't fix it, and your shortcode can be shut down and your campaign can be terminated. Mobile Marketing Association, nothing will happen. TCPA, though, it gets pretty serious. There's 3 different things that can happen if you violate the TCPA. 1, consumer lawsuit. Consumer is your customer, most likely. Recipients can claim damages of up to $500 for each text message. Now, if you send 1 million text messages, that's not $500, in damages. That's $500 times 1 million text messages. So it gets pretty expensive if you start, not following the TCPA when sending your text messages. It gets even worse, though, if your business is willingly or knowingly violating the TCPA. So if you know about the TCPA, like you're watching this webinar right now, or you've downloaded our guides and you know that you're violating these rules, the court may increase damages to $1,500 per text message. Again, that's $1,500 times the 1 million text messages. So it can be very, very expensive to violate the Telephone Consumer Protection Act. This is really where the majority of TCPA concern, TCPA lawsuits, this is where businesses focus their efforts. Now, also, a state can initiate civil action against your company. That's another enforcement tactic. And complaints may be filed with the Federal Communications Commission, the people that enforce it and everything, which has the power to assess penalties against your company. So not only can you be sued by consumers, and the state can initiate civil action against your company, the FCC can also assess penalties against your company. At the end of the day, violating the TCPA with text message marketing is not worth it. It is very, 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 very costly. It is much easier to put in the disclosures and make sure that customers are opting in properly and they're opting in with the disclosures that are needed that we reviewed earlier. It's not worth it. There's no reason to spam a customer and, number one, infuriate and, frustrate your customers and make them mad. And number 2, open yourself up and open your business up for a lawsuit that, could cost, millions to hundreds of millions of dollars. Okay, let's talk about record keeping in disputes. When you do all of this stuff, and hopefully you're doing it properly because you've watched this webinar, there is a burden of proof. So if someone does come, to an attorney and say, hey, I received this text message spam, the attorney, will come to you and say, hey, you're gonna have to prove this. It is your business's responsibility to bear the burden of proof for both to demonstrate that a clear and conspicuous disclosure is provided and the customer consented to receive text messages to the number he or she specifically provided. Okay, pretty much all the stuff, you have to prove it. And it's your business's responsibility to prove it. So to protect your business, it's advised to maintain each customer's consent for at least 4 years, which is a federal statute of limitations to bring an action under the Telephone Consumer Protection Act. So keep things for 4 years. What does that mean though? Like, how do I keep things? Okay, so for a mobile opt-in, you really only need to keep like how they opted in. For a mobile opt-in, that means they saw a billboard and it said text pizza to 33733 and they want to opt in. Keep copies of all advertising that promotes your SMS campaign. If you run a billboard, keep a copy of that. Don't keep a copy of the entire billboard, but keep a copy of the picture of the billboard so they can see that disclosures were made. If it's on a website, take a screenshot. If it's in store, take a picture of it, or take the PDF file that you make the in-store advertisements from and save that. And then keep a record of all mobile terminated and mobile originated messages. This an SMS provider will do for you. So companies like Tatango that are SMS providers, we will be able to pull a log of that consumer's mobile phone number and say, yes, they saw the advertisement and you have a copy of that advertisement as a business, and they texted in this. We sent them a message to confirm that they're opting in, and then they received all these messages and it's CTIA compliant. If you have those things, you are doing what you should do to protect yourself from disputes regarding the TCPA. Now, web opt-ins, if you have a customer type in their phone number into a website, I would recommend screenshots of the consent web page as seen by the customer, complete data records submitted by the customer. This means things like IP address, what other information they typed into the computer at the same time, things of that nature. And then keep a record of all mobile terminated, mobile originated messages. That's usually the SMS provider's responsibility. But you need to make sure the SMS provider is actually doing that. So question your SMS provider, because it's your responsibility as a business to be in compliance, and you have the burden of proof. So you have to make sure that the SMS provider is doing it, because if the SMS provider is not doing it, you're liable. Okay, let's talk about some notable TCPA lawsuits. Hopefully these will scare you enough. The $500 fine up to, not even fine, it's consumers can sue you for up to $500 to $1,500. Hopefully that scared you. This, though, should really scare you, because this is real businesses that blatantly violated, the Telephone Consumer Protection Act. And as you saw, it is so simple to comply with the Telephone Consumer Protection Act. People think, oh, it sounds so Telephone Consumer Protection Act. It sounds so complicated. It's not that complicated. It's 2 little disclosures on your advertisement. That's it. And making sure you're doing, everything properly and keeping records. But it's not that hard. And these companies, as you'll see, this is not to scare you away from text message marketing. This is just to make sure that that, if you don't follow the rules, this is what happens. So Steve Madden, they have shoes, they create shoes. So the TCPA violation is, according to the lawsuit, consumers claim that Steve Madden sent them text messages about Steve Madden products and events without their consent. It's a blatant violation of the TCPA. The TCPA says you have to get consent from your customers. If customers didn't consent to receive text messages, then you're in violation of the Telephone Consumer Protection Act. This one's a pretty easy one. Pretty easy, and the settlement was $10 million. That's a lot of money. That's a good reason why you want to get consent from your customers. Not only was the settlement $10 million, that angered a lot of customers and put Steve Madden in a bad light, which no business ever wants to do. So just follow the TCPA. Papa John's. This one's a great one. Not great, but it's a great example of somebody definitely flagrantly violating the Telephone Consumer Protection Act. According to the lawsuit, Papa John's franchisees sent text messages to consumers that had previously purchased pizza. That sounds like back in the day what used to apply, but now the law has changed, as we all know. Instead of, this would apply to someone having a previous business relationship with someone. So back in the day, this might have not been an issue, but because the law changed, it is an issue. In order to get them to order pizza again, Papa John was unable to provide any evidence. Again, they violated the Telephone Consumer Protection Act. That's the first issue, because they didn't get consent from their customers. They were just taking phone numbers of people that had called in and said, hey, because you called in, we're going to text message you now. They didn't really even tell customers. They just text messaged them. Second part, though, they didn't even keep records of the opt-in. So even if they did have opt-ins, they didn't have the records, they would still have a problem. So they're unable to provide evidence. Any customer who received the text message gave their consent. The reason they couldn't provide the evidence is because the customers never gave their consent. The lawsuit the attorneys are suing for $250 million. I doubt the attorneys and the consumers will get $250 million, but they are suing based on the $500 and the $1,500 numbers, and how many people receive these text messages. That's a big number, $250 million, plus angering all your customers. Great reason to follow the TCPA. And again, as we've discussed before, it is pretty easy to follow the TCPA, so why not? Jiffy Lube. This is a great one. We wrote and followed this case, I think it was over a year or so. A blatant violation of the Telephone Consumer Protection Act, and very similar to the last one. According to the lawsuit, Heartland Automotive Services, the largest Jiffy Lube franchisee in America, sent over 2.3 million with an M, consumers text messages without their consent. Again, are you seeing kind of a pattern here? It's not that hard to follow the TCPA. You just got to get consent from your customers. What they were doing is when you would call in to Jiffy Lube and you would say, hey, here's my car, and they put your name down. They'd also take your phone number. And what they decide to do one day, and I received this text message, a lot of people throughout the country received this text message, 2.3 million people, is they sent out a text message and they said, hey customers, good to hear from, or, we wish to contact you again. And what was interesting is they said in the text message, to receive coupons and promotions, reply yes. And they thought, we're totally within our rights because customers will opt in. Unfortunately, though, with the Telephone Consumer Protection Act, it says to send a text message to a customer, you have to first get them to consent. You cannot, under the Telephone Consumer Protection Act, send a text message to a customer that has not consented, asking them to consent. It almost gave away in the text message that they had not received your consent because they wouldn't be asking for it in the first place. Most ridiculous thing ever. Again, the settlement in this Jiffy Lube lawsuit was $47 million. That's because they sent 2.3 million text messages, all to consumers without their consent. If they would have had customers come into the store and either electronically or with their signature say, hey, if you're bringing your car into Jiffy Lube, would you like to receive text message promotions? And then disclose that they're going to receive the text messages based off a telephone automated dialing system, and that they don't have to do this just because they're purchasing something. If they would have got all 2.3 million people to say that, this would not even be a lawsuit. It would be a great SMS campaign, and they'd be generating millions of dollars in revenues rather than millions of dollars in settlement fines. Another one, this one's a little older, 20th Century Fox. According to the lawsuit, 20th Century Fox and Fox.com sent unsolicited, again, the TCPA has two little things, and the majority of it, the business is just sending unsolicited text messages. That's the first one. The second part of the TCPA is that they have to make sure that, the consent is not a condition of purchase. Most businesses understand that. Like, you don't go into business and they're like, well, we're going to need your phone number and you're going to have to sign up, if you want to pay for this, because most businesses want the money first, so they're not going to put barriers in place. But there were businesses back in the day that used to do this. So you don't see very many lawsuits regarding the second piece just because it doesn't happen very much. The first one, though, you have to get consent. If you don't get consent, it's unsolicited. Therefore, you get sued, just like 20th Century Fox. They sent unsolicited text messages to consumers advertising the DVD release of animated motion pictures robots. I think in this case, consumers had opted in regarding some other DVD, like another movie, and then they said, yes, I want to receive text messages from this movie, not from 20th Century Fox. And then 20th Century Fox took that list and took those phone numbers and sent them messages about another movie. That's just the exact same. If you're a business, you're a pizza place, and everybody consents to receive pizza text messages from your pizza place, and then you go and copy that list and give it to a tanning salon that has nothing to do with your business. The tanning salon cannot use the consent from the pizza place to text message you, because you as a consumer did not opt in and consent to receiving text messages from the tanning place. You opted in to receive text messages and you consented to the pizza place. So don't think that if you buy a list online, it says, oh, these people all have consented. Yes, they consented for one thing, which is that one business, maybe. I find it very, very hard to believe that people just consent to receiving random text messages. Again, you don't want to buy a list online. That's another topic. But if you did buy a list, they have consented to something else. They did not consent to receiving messages from your business. So do not text message them. That is a big violation of the TCPA. This settlement in 20th Century Fox was $16 million. In addition to people not being very excited about robots because the 20th Century Fox was pretty much spamming them about this new robots thing. That just made people angry. Simon & Schuster, they are a book company. They did a similar thing. Luckily, they only did it 60,000 phone numbers, where, remember, Jiffy Lube was like 2.3 million. According to the lawsuit, Simon & Schuster sent unsolicited text messages promoting a new book to 60,000 phone numbers, a $10 million lawsuit. If your business does not want to be sued under the Telephone Consumer Protection Act, the answer is not to not do text message marketing. It's to do it properly. And as you've seen in this presentation, this webinar, it's pretty easy to do it properly. So why not do it properly and avoid all of this other stuff? Settlement was $10 million. Coca-Cola, this is a completely different one. Remember we talked about that the TCPA requires an opt-out mechanism. This is interesting because Coca-Cola, according to the lawsuit, the plaintiff is the customer, continued to receive unwanted text messages from Coca-Cola regardless of their attempts to opt out and despite Coca-Cola's own confirmation that the defendant would no longer receive text messages. This one's interesting. It seems like, and again, I don't have all the facts of this, but it seems like the customer opted in because they're not suing based on the consent law. They're saying, hey, I opted in to receive text messages from Coca-Cola and I consented, which, I'm okay with. But when I wanted to opt out, I couldn't opt out. Therefore, I attempted to opt out, and because of that, because I could not opt out, I can now sue under the Telephone Consumer Protection Act. This case is still ongoing, so there's no settlement yet. But a lot of people, they think SMS providers are all the same. It's a dime a dozen. They're all sending text messages. This is most likely, again, I don't have all the facts, but most likely this is a fault of the SMS provider. The SMS provider is supposed to process opt-outs for the brand with the text messaging campaign. It looks like from what the plaintiff is claiming is that the plaintiff, the customer, texted stop, most likely, to the short code. It said they opted out, but the SMS provider didn't process that message, didn't process the opt-out. Therefore, because of the SMS provider, not even the brand in this case, because of the SMS provider, the brand is being sued under the Telephone Consumer Protection Act. So not only do you have to make sure you get consent, which is easy, and you have to make sure that it's disclosed properly, and that also the condition that you don't need to make you don't need to opt in to purchase something. In addition to that, you also need to make sure you select a good and reputable SMS provider that when someone opts out or opts in, it actually is done and the records are kept properly. Because if it's not, you get things like this. That's it. I am a little concerned that, obviously this was a long webinar, but remember the pieces of the TCPA that you have to comply with when you're doing SMS marketing, there's only a couple things. It's consent. They're receiving automated telephone messages. Number 2 is that consent is not a condition of purchase. That's pretty much it. Then there's a lot of other stuff around that, not a lot, but a few. You have to make sure it's disclosed properly. You can't just hide it somewhere. You have to keep your records. That's pretty much it. It's pretty simple. We went through the laws and the case history and the history of the TCPA and what the MMA requires and the CTIA and all these things. But if you're looking to be compliant with the TCPA, which you should in an SMS marketing campaign, don't think it's complicated. As we saw in this webinar, it is actually pretty simple. And as you saw from those lawsuits, it's not rocket science when you do violate the TCPA, and it's not rocket science to not violate the TCPA because you got to follow only like a couple rules. Anyway, if you have questions about the TCPA, about CTIA, about combining those two things, about past lawsuits, concerns about your campaign, number one, we always recommend talking to your own attorney. But from an SMS marketing standpoint, feel free to email me. My email address is derek@tatango.com. I'm on Twitter at the Derek Johnson. I am the CEO of Tatango. I love talking about SMS marketing. I love talking about the laws. I love talking about the requirements, by the CTIA. And we work very closely with the CTIA to not only form, what is required in the CTIA guidelines, but also, how it's required, where it's required, how that document progresses, the history and the future of the CTIA requirements. I'm very, very involved in this. So I love talking about this kind of stuff, and I love helping businesses get through the TCPA and the CTIA and all those things, because once you get those things in, under order and everything looks right, then you can start building your subscriber database. You can collect your customers' phone numbers without concern. Then you can start sending promotions to your customers, and you can make money as a business. You can have a great marketing channel, and you don't need to worry about all this TCPA and CTIA stuff, because you do it once and you set it up and it's done. Anyway, that's the presentation. Feel free to contact me. Again, my name is Derek Johnson from Tatango, and I'd love, if you have any questions, just email me. Thanks.